Good evening and welcome to this session of the live virtual classes conducted by the Board of Studies of the Institute of Chartered Accountants of India, academics of the Institute of Chartered Accountants of India. Today, the topic we are going to see is incorporation of company and matters incidental thereto. You have already gone through the first chapter, which is preliminary definitions, etc. Now you are going to go through the incorporation of the company topic, pretty lengthy chapter covering preliminary issues like how a company is to be incorporated, types of companies, etc., etc. Since in preliminary, you might have gone into the definitions, permit me to reinforce the fundamentals of this subject. The subject you are going to study is called company law. It is contained in the Companies Act 2013. Okay. Give me 1 minute. Maybe I think I have. Just give me 1 minute. I want to just be sure that I am having the right. Yeah. Skip a couple of slides. That is the problem. Yes. So the topic that we are going to study. Hey, okay. I know what it is. So the topic you are going to study is called company law. It is contained in the Companies Act 2013. Okay. The Companies Act is a mammoth. Mammoth means huge. Mammoth is a huge elephant, just 3 times bigger than our normal elephant. It is an extinct species. So the Companies Act is a mammoth. So when we use the word mammoth, it means huge, humongous legislation. Currently, it is reduced size. That is 470 sections. In those days, it had 700 sections. In the old law, Companies Act 1956 had 700 odd sections. And 16 schedules. Now we have 470 sections and 7 schedules. Okay. Though it is mammoth legislation, is still the basic principles are very few. Once the basic concepts are understood, the details are easy to learn. So what you have to attempt is not to try to mug up or to follow the institute material blindly. I'm not saying do not use the study material. Study material is the only and best source for you. But do not be blind. When you are reading anything, please understand what is the basis. Why is it like that? Then read. It will be easier, which is what I'm going to do. I may not always follow the study material pattern. I cannot, because I am going to go logically. So there may be a slight. So please, during the session, do not ask me which page of the study material, etc., because I do not have the study material with me, nor can I tell you which page, etc. You have to diligently search and locate the particular area. 100% everything will be covered. It is there in the study material. Outside of the study material, I'm not teaching anything. Everything in the study material will be covered, but not necessarily in that order. So best suggestion to you is, please do not do double study, looking at the screen, listening to me, looking at the material. Don't waste your time. Later on, you can always do that. Or if you are very smart, without disturbing me, do it. Do not at any stage put a message asking which page are you in, which page is it? Tell me, like that. No, do not put do that. Also, any technical issues which you might have, please do not put it in the query pad or do not expect me to react to it. The technical person who is here will maybe see it and maybe react to it. Okay. So I don't know what is the procedure for that. Please do not disturb the class on technical issues which are not mine. If there is a technical problem at my side, only person who will inform me is the technical administrator from the institute who will tell me there is a problem, then we will decide what to do. You don't bother me. Because many times I have found that the problem is not at my end or the institute end, but at the participant end. So please, these are all basic suggestions I'm making to make the learning process easy. Otherwise, if you are having a good connectivity, say just sit back, listen, take notes. In addition to what is there on the screen, I will also be telling many things. Some of it is relevant. Please take notes. Write down what I'm saying. Okay. So in these slides and the lectures that are going to come, my lectures, I have arranged the material in such a way as to enable you to remember the details. So most of my slides will be easy. In the past, many students have used my slides either by listening to me directly in online class or downloading my video lectures from the BOS portal. And whenever I meet them across the country when I travel, they come to me and they inform me that they have found my lectures and my slides very useful. The slides will be uploaded in the portal once the classes are over. That is, once this topic is over, I will upload it, which means 6th August, this topic will be over. At that time, I will upload it. Till such time, I will not upload. Okay? Are we clear on the basics? Now, any query you might have, you can either put it on the query pad or you can put it on the chat box. Both are perfectly all right. If you are unable to access the query pad, I have no botheration. Please don't inform me. You just proceed. Whatever you want to do, you do. But if you have a query, whichever is convenient, you put it there, either chat box or in the query pad. Whenever I come to a logical stop, I will do it. Okay. So, Rosi Valia wants, we are now going to see chapter 2. Chapter 2, incorporation of company and matters incidental there to chapter 2. Once again, I repeat, please do not do comparative study and do not ask me which page where, etc. I cannot tell you because I do not have the institute material open in front of me. So please do not ask me. But logically, I will go. Topics will be covered. Don't worry. Okay. Trust me, come with me on this journey of learning. You will not regret it. Okay. But if you're going to do audit of what I'm teaching, on your own, you do it. Don't do anything. Chapter 2, though, 2, okay, of the Companies Act. Study material also 2. Okay. So, one easy way of understanding company law is the one taught by my own guru, a great man called Professor K.S. Anantaraman, a very leading advocate who has written books on company law. He has understood this topic in this way. The entire framework of company law has two basic purposes. The two pillars, we can call it, which uphold the building, the edifice, which is called company law. Okay. One is protection of the investor. Who is the investor? The person who is applying for and investing in the company in form of shares. Okay. When you come to the topic share capital and debentures, you will find mainly protection of investor would be covered. Here also, in incorporation also, we will be seeing a lot of protection for a investor. Okay. The investor is a person who invests in the shares of the company. Means equity or preference or differential voting rights. So this is called equity. So the law wants to protect the investor from unscrupulous company directors and management and promoters. Two, to protect the creditors. So those people who have lent money, including debenture holders, depositors, etc. So the idea of the Companies Act 2013 and its predecessor, the 56 law, is to protect the investor, protect the data. So any section in the Companies Act, if you see it, it will be aiming at protection of the investor or protection of the creditor. Okay. Of course, we may also add public interest. That is, it may not have impact on investor or creditor, but the behavior or activity of the company may have an impact upon the national economy or on share market or on whatever it is, public policy. So there, central government only can enter. Central government only will decide whether it is contrary to the public interest or not. You and I cannot decide public interest. Central government only can. The word central government has a peculiar meaning. In this, for the administration of the Companies Act, there is a separate ministry called the Ministry of Corporate Affairs. The Ministry of Corporate Affairs, MCA, popularly abbreviated as MCA. MCA is the administrating ministry. So whenever we use the word central government, we mean the Ministry of Corporate Affairs consisting of various officials such as regional director, registrar of companies, director, assistant director, deputy director. So distribution of powers is very clearly given. Wherever necessary, I will tell you who is the central government. Wherever necessary, I will tell you whether it is ROC or regional director, or you have to go to Delhi directly to the ministry. Okay, so I will tell you. So as you are all well aware from your studies, right from +2 onwards, you have studied this. Company is a separate legal entity distinct from its members. This means company can own property and dispose property in its own name. It can file a suit and defend a suit in its own name because it is a separate legal entity. It has perpetual succession. That means even if all the members of a company die, the company will not die. The company will continue. This is called perpetual succession, right? You might ask me, sir, if all the members die, what happens? Don't bother. The legal representatives will take over. Legal heirs will take over. What is your problem? Company will not die. The company can continue to function. Got it? Even though all the members have died, there will be a succession. Okay. Now, it has perpetual succession and can be formed only for lawful purpose. Okay. The company, being a legal person, is created by a process of law. Okay. The process is called incorporation. Okay. That is what we are going to see today. The company is a legal person. It can be formed only for lawful purpose. You cannot form a company called Smugglers Limited or something limited like that. Okay? No. Smuggling being an unlawful purpose, you cannot form a company for that. Okay? But for any other lawful purpose, you can form a company. The process of creating a company is a legal process, and this process is called incorporation. Today, or in the course of these lectures, we will be seeing the process of incorporation. Right? The term promoter is already defined for you. Nevertheless, because it is the promoter who takes the effort to incorporate the company, we will have to understand this. Okay? If any person who is been named in the prospectus, after this topic, you will see prospectus and allotment of securities. In that chapter 3, you will learn about prospectus. Okay, so do not bother what is a prospectus, except to say it is an invitation to the public to subscribe for shares in or debentures of the company. A prospectus is an invitation to the public, calling for applications for shares in or debentures of the company, right? So any person who is named in that document, prospectus, as a promoter, is a promoter. Or if he is mentioned in the annual return, which is filed every year by the company, he is identified as a promoter of the company. There again, he may not be a director, please note it, or even a shareholder. But if he is named in the prospectus as a promoter, he is a promoter. Or he or it, the company can also be a promoter. Okay. Who has control over the affairs of the company, directly or indirectly, whether as a shareholder, director, or otherwise. Such a person also is a promoter. Any person who has control over the affairs of the company, maybe as a 51% shareholder, or holding shares together with his relatives. That is what they mean when they say indirectly. Indirectly means not, it may not be by himself, it may not be on his own, it could be through or with his relatives. So Mr. A doesn't have one share in that company, but Mrs. A is holding 51% of the shares. Who is a relative? Wife is a relative. Therefore, indirect. You already seen the definition of relative. So you know what is a relative, right? So wife is a relative, right? Indirect. So directly or indirectly, whether as a shareholder, director, or otherwise, or in accordance with whose advice, directions, or instructions, the board of directors of the company is accustomed to act. Although the company has board of directors, these directors have no separate thinking brain. Simply they will obey what their boss is telling. He is not a director, he is not a shareholder. His name is not coming anywhere. But the board of directors of the company is accustomed to act in accordance with the directions of this person. Okay. Of course, you can say, sir, auditor is also giving advice. Advocate is giving, banker is giving. Are they then promoters? No, because they are acting merely in a professional capacity. See, as an auditor, I will tell them what to do, what not to do, and all. Doesn't mean that I am a promoter. Okay. So, definition of promoter. Let us see, two items are there in chat. Let us see what they are. Yeah. See, I will try to come as near as possible to the speaker, but I'm not able to raise my voice beyond a limit. Okay, kindly bear with me, Mr. Ashutosh Bharati from the central region. Okay, this is the best I'm able to manage. Now, the whole point of this official definition is only to identify the persons to be punished in case there is a misstatement in prospectus. The idea of this definition is not to define, but to identify people who will be punished in case of misstatement in prospectus. So, we still don't know who is a promoter. Therefore, we can give a general definition. A promoter is a person who, first of all, has the idea of forming a company is first conceived in the mind of the promoter. Okay. They only have the idea. They undertake the process of incorporation. They bring the company into existence. Such people are called promoters. Suppose I were to ask you, who is the promoter of Reliance Group? Who is the promoter or who was the promoter of Reliance Group? Anybody? Who was the promoter of Reliance Group? Ashutosh, I'm shouting. My throat will go. You come nearer and listen or use a earphone. Okay, you mean whatever. Use a, what do you call that? Speak. Hey, what do you call that? Yeah, phone. Like earphone or whatever, speaker or whatever. Use it. Put it on here. It will be easier. Okay, no problem. Yes, Dhirubhai Ambani is the correct answer. Mukesh was not even, I think he was just born at that time. Okay, Dhirubhai Ambani. Dhirubhai. Zunabo Malik has written correctly. Absolutely correct. Dhirubhai Ambani, the great man, was a promoter of Reliance Group. Dhirubhai Ambani. Later on, his sons Mukesh and Anil joined the company. Then, after the death of Dhirubhai ji, Mukesh and Anil split the company. Anil took his part and called it ADAG, Anil Dhirubhai Ambani Group. And Mukesh, of course, got Reliance Industries Limited, which now controls Jio, a very powerful telecommunication giant, and also a retail giant. They also have a retail division. They are also into energy. They are into petrochemicals. It's a conglomerate corporation. Reliance Industries Limited is a conglomerate corporation. Okay, it's a conglomerate. Conglomerate means it has many business operations. Not only one, it has many business operations. It is a complex business, very successful business. Okay. So just to give you a concept of promoter, I'm telling this, not to film industry also, but that was ADAG. That is ADAG. I think that is ADAG. Don't confuse ADAG with the main Mukesh Group. Mukesh Group, alage, ADAG, alage. ADAG is out. ADAG is gone. Okay. It is gone. ADAG is gone. It was Anil Dhirubhai Ambani Group. Reliance Infocom, Reliance Finance, Reliance Capital, they called it, all sorts of things. Of course, they are heavily in debt and not doing well. Okay. Film industry, I think ADAG Group went it, not Mukesh Group. Anyway, that's absolutely, it's a huge conglomerate capable of, I think the Reliance Industries Limited also owns the Mumbai, IPL team. They own it, I think, to my knowledge. It's on the balance sheet of Reliance. Okay. Now, a promoter has a very peculiar relationship with the company. He cannot be called as agent because when he is conceiving the idea, the principle, the company has not come into existence. Any contract entered into by a promoter cannot be binding on the company. This is called pre-incorporation contracts. They cannot be binding because at the time when the contract was entered into, let us say that the promoter is an agent, where is the principal? This non-existent principal cannot be bound. The company comes into existence later. And at that time, after that, if the directors enter into any contract officially on behalf of the company, then the company is bound. Till such time, company is not bound. So promoter cannot be an agent. Also, he cannot be a servant because there is no master. Also, he cannot be called as a trustee because trustee cannot make profit. Trustee cannot sell his own property. But the promoter can sell his property or business and he can make a profit. Now listen carefully. Promoter can make a profit by selling his assets to the company. But such a profit should be reasonable and what is normal arm's length, and it should be disclosed. Very important. It should be transparent. This is the market value of the property. I'm giving it to you at the market value. Okay, then no problem. But suppose he is giving it at a price higher than the market value, then there is a secret profit, which is undisclosed, that the promoter cannot take. Promoter has to refund it back to the company. Here is a case law on this. Erlanger E was the head of a syndicate. Syndicate means group of people who come together to conduct a business. Syndicate could be a group of companies or a group of individuals. They want to pool. It is not a partnership because in partnership there is mutual agency. Here there is no mutual agency. They are merely coming together. It's more like a joint venture. They are coming together only for the purpose of a single activity. And this Erlanger was the head of the syndicate. Now the syndicate purchased an island in the West Indies, which contained valuable mines of phosphates. So maybe they did a study and they found that it has. The purchase price of this island was 55,000 rupees. It's not rupees. In those days, it is English case law. 1873 case law. Must have been in pounds. Great Britain pounds. He formed a company to buy this island. Okay, so he formed. First, they located the island, which contained valuable phosphates. Purchase price 55,000. Then he forms a company. Okay. And then X, a nominee of the syndicate, on behalf of the syndicate. See, the syndicate purchased an island. Now the syndicate owning island, which is costing 55,000. Company is formed. Then X, a nominee of the syndicate, so that they are hiding behind X. He sells or enters into a contract with the company to sell the island to the company for double 1,10,000. Now this, it's more, see, they can have a reasonable profit. 1 lakh, and that too undisclosed. They have not disclosed it to an independent board. Therefore, they said the company was, the court in appeal, the Court of Appeals in England, they held that the company was entitled to resign the contract. Resigned means to set aside, to reject. The word resigned, if you don't like it, you can use the word reject the contract, set aside the contract and say we are not bound by it. And whatever money was paid to E, it can be recovered from E and the syndicate. This is a case law which is called Erlanger versus New Sombrero Phosphate Company, right? So this is well-known case. You may want to remember this Erlanger versus New Sombrero Phosphate Company. To be a promoter, one need not necessarily be associated with the initial formation. Somebody who comes later on to arrange capital, floating of capital, will also be regarded as a promoter. That's why we say any person whose name is mentioned in the prospectus is a promoter. Okay. So this is with regard to promoter. Let us see if you have any specific question on promoter. Now I have a small request and suggestion. I have a small request and suggestion. Do not ask me to repeat the case law because Mr. Mohan Raj, time is very, very limited. Okay. If like you, everybody says repeat, I cannot talk. I cannot cover this topic. So what you should do, specifically what you have not understood. Or one more method is there. Easily Srikanth can repeat it 100 times. You know how? Wait for this class to get over. Then download the video, play it. I will explain once. Rewind, play, rewind, play. How many ever times I will come and repeat it to you? You are able to understand. So please, from now on, refrain from using this comment. Repeat like that. No repeat. Okay. Specific questions on this topic. What you don't understand? There is a syndicate. They buy the island. Their price is 55,000. Thereafter, they form a company. Then X is nominated. X, on behalf of the syndicate, sells it at an atrocious price of 1,10,000. Sells a profit of 55,000. Not disclosed to the company. Not reasonable. Therefore, company is entitled to resign. So the principle is, if the promoter wants to sell, the profit should be reasonable and it should be disclosed. In this case, profit is not reasonable and profit was not disclosed. Therefore, company is not bound to pay. If any money already paid, they can take it back. I have repeated it in very simple, Asan words I have repeated. Now you tell me, have you understood? Yeah, resigned, I explained it to you. Reject, set aside, not be bound, like that. Okay. Resigned means, that is, there is a contract between X and the company. The company can say, I am not bound by this contract. I am not bound. I don't have to pay you 1,10,000. That's what it means, resigned. Resigned is a technical term. Resigned means to set aside, to reject and recover. See, if I, out of this 1,10,000, suppose I have already paid 1 lakh, I can recover it from E. Okay. That is what it means. Clear? So this is the relief that the court can give, right? So if you ask specific questions, it will be very useful to all of us rather than repeat. Because see, I will be fumbling in the dark. I will not know what is it that this gentleman or lady doesn't understand. And I will be giving some explanation. Still, you will be unhappy because you will want some explanation. With this poor idiot would not have given. So, intelligent student will ask specific doubt rather than repeat. Okay. Why I see seriously repeat? I mean, because this is not the first time you are going to say repeat. You are going to sleep, wake up, suddenly say repeat. It's not going to happen. If you want me to repeat it, don't bother. Wait for this class to get over. 100% this video will be uploaded. You will get a link. From that link, you download. Keep on listening. Yeah, I will repeat it 100 times also if you want. Whereas if you have a specific doubt and ask me, I will clarify. Okay. This is not only for you, sir, Mohan Raj, sir. It is for everybody here who is joined as a general humble request to all. Now, we come to the next topic, which is types of companies. Basically, you can have incorporated company, unincorporated company. Okay. Incorporated company will be a registered company. This will be the maximum category. This will be the maximum. This will be the main. Most of the time, you are going to be concerned only with this category. Registered company means what? A company incorporated or registered under the Companies Act 2013 or under any earlier Companies Act. So before this Companies Act 2013, there was a wonderful enactment, very beautiful law, which was the 1956 law. That beautiful law has been, there were certain small defects. It could have easily, some sections could have been removed, cleaned up and renumbered. We would have had a beautiful law intact, and some concepts which are now here, which are good, should have been added there, possibly by people who knew how to write good English. But they have totally destroyed that old law and created a new law called 2013 law, which is, there are a lot of issues. When we go into the sections, I will be pointing out, and I will be very critically talking about sections. I am not here to defend these sections. I am here to teach company law. I am not defending the ministry. I am not in any way bound to defend the Ministry of Corporate Affairs. Right? Just like I am not here to defend the Ministry of Finance or the Department of Income Tax Department. I file appeal against them every month. I file two appeals saying that the department is wrong. Okay. So as a chartered accountant, I don't have to be afraid. There is a judicial process. There are courts, tribunals to help me. So long as my client is within the framework of the law, why should I be afraid of government officials? Okay. So the registered company is a company which is registered under the Companies Act 2013, current law, or the earlier law. Before 56 law, there was a 1920 law, British law, which was applicable to India, Indian Companies Act. Okay. So like that. No. The point is, whatever it is, it should be registered under an existing company law or an earlier company law, right? There are companies that are 200 years old in India. In India, we have companies which were incorporated in those days. Okay. Of course, in prospectus, I would have taught you, but quickly I'll ask you, which could be the oldest company in the world? First incorporated company incorporated first in the world. Well-known company. First in the world. Not in India. It is the East India Company. But be careful, because every country from Europe had a East India. SBI, he knows that. SBI came much later. About the history of SBI a little bit later. First ever joint stock company was formed in England. It was the English East India Company. British East India Company. The next company was the Dutch East India Company. Okay. Now, and between them, they were very competitive. Not only in India, though they called East India Company, they were also in West Indies. They were also fighting in Jamaica and the entire Caribbean coast and Caribbean Sea. And also they were everywhere, Malaysia, Singapore, you name it, these two fellows were fighting. Thailand, Bangkok was not there at that time. There was a city called Ayodhya, where they tried to go and influence. China, they were fighting. So the English East India Company versus the Dutch East India Company. Dutch East India Company is from a country called Netherlands. Now that country is called Netherlands. Once upon a time, it was called Holland. Okay, Holland. Now it's called the Netherlands. The capital, Amsterdam. The SBI, State Bank of India, is not the oldest company in the world. It is not even the oldest company in India. But before SBI, there was it was, first of all, not a company also. It was a chartered bank. It was chartered by a royal charter of the King of England. It was called the Imperial Bank of India. Imperial Bank of India. Post-independence, the Imperial Bank of India became the State Bank of India. Okay. More of the State Bank of India, but it is not, by no stretch, it is the oldest company either in India or in the world. But it is a very old company. Definitely an older company. But there are companies which were formed before SBI, which are still in existence. Okay. Under the British law. They are also functioning in India. Okay. Good. Moving on, statutory companies. Now, statutory companies are formed by an act of parliament. So, the government of India wants to do something in some area, form a company. Instead of registering under the Companies Act, they will create a charter. Now, the State Bank of India is a chartered company. Are you able to understand? Post-independence, when they wanted to take over the Imperial Bank of India, the Parliament, the then Parliament of India, passed a law called State Bank of India Act. And then State Bank of India was formed by an act of Parliament after independence. And that State Bank of India took over the Imperial Bank of India. The assets and liabilities, deposits, businesses are all taken over. Definitely, if you are living in a metro city, there will be a State Bank of India office which would be minimum 100 years old. Minimum 100-year-old office will be there. In Mumbai, Chennai may be there. Delhi, I'm sure it is there. Kolkata, definitely you will have a State Bank of India office building, which is a heritage property. More than 150 years old property should be there, which would be belonging to State Bank of India, which originally belonged to the Imperial Bank of India. Okay. In the First Line Beach in Chennai, we have a heritage building of State Bank of India. To my knowledge, it's 200 years old. It's 200 years old. And that building. Okay. And so, then, of course, you have chartered companies, which are not possible in our country. Why? Because our country is a democracy. In a democracy, we can have statutory company formed by a parliament, which is members of parliament elected by the people of this country. We are a democratic republic. Therefore, sovereign democratic republic. Therefore, we cannot have charter. But countries like England, which still have a monarchy, where there is still a king. In Thailand, there is still a king. Now, these countries, the King of England, by his charter, in other words, there will be a parchment paper where the King of England, you should read. See, the English East India Company was a chartered company. It was chartered by the then King of England, King George V. He chartered this company and he sent it all over the world. And I think, no, not King Edward. It was chartered by before Victoria. 1857, Victoria becomes the Queen of India. Before Victoria, sorry. George comes later. Okay. George comes later. So George V comes later. Then, of course, his son George VI, his daughter Elizabeth II, and her son Charles II. Now we have Charles, King Charles. Okay. So this was chartered even before Victoria. Okay. Must be Edward. I think it must be Edward II, who would have chartered the company. And that chartered company became the chartered company. In unincorporated companies, see, some firms which have been formed under the Partnership Act may want to get wound up under the Companies Act, may want to be closed under the Companies Act. If so, they would come here as unincorporated companies. Otherwise, not many. Our main concern is only registered company, right? Let us see what are all the thing. Yes, Dutch East India Company was the second. Dutch East India Company was the second old after East India, 1600, 1604. 1600, English East India Company, 1604, Dutch East India Company. Okay. Yeah, once the East India Company came to India, they entered into not charters, they entered into agreements of trade with, of course, in his own right, the Mughal Empire would have given Emperor Farooq Shah. I don't know. Weren't the Mughals there at that time? Must have been Jahangir, because English East India Company came during Jahangir's period. The first time British came was Jahangir, then Shah Jahan. Thereafter, the English East India Company was very much there throughout India. They had their main headquarters in Surat and so on and so forth. Anyway, let's not get into too much history. It was Jahangir, not Farooq Shah, Jahangir. So the first time the British came to India in the period of Jahangir. When it's formed under a special law, it is called statutory company. Statutory company when it is the first by when it is active. But today, many of these so-called statutory companies, which have been formed under special law, like State Bank of India Act, Life Insurance Corporation of India Act, IDBI Act, ICAI Act, all of those acts have been repealed. And these companies, they have made an application to the Ministry of Corporate Affairs and got themselves, or the Ministry of Department of Company Affairs under the Ministry of Law and Justice, and they have got themselves incorporated under the Companies Act. That is, these companies have surrendered their statutory status. Why? because post 90s, 97, 98, they wanted to enjoy the benefit of IPO, public issue. The government wanted to disinvest post 90s. And in order to enjoy the benefit of disinvestment, the government of India forewent its act status. And they said, we will become limited company. And that is how Indian Oil Corporation, which is a corporation formed by the government of India, a chartered corporation, not even a company, became Indian Oil Corporation Limited, a company governed by the Companies Act 2000, then 1956 Act. Okay, like that, the insurance companies, they were all statutory. They were formed by acts of parliament. The four insurance companies, everything, ONGC, everybody, because they wanted to go for public issue. Okay, so for that, when SEBI came in 1992, they said you have to be incorporated and bound by the Companies Act. So they immediately, BSNL, the Bharat Sanchar Nigam, it was not limited. Bharat Sanchar Nigam became Bharat Sanchar Nigam Limited. Okay, just like MTNL. Okay, so all that good. Okay, now registered companies again divided into many types. Basic division: private company, public company. In those days, under the old law, there was a huge benefit in being a private company. Many section will not apply to private company. Private company enjoyed many exemptions. Today, under the new law, private company doesn't have that many exemptions. There are a few, but very difficult to apply. So it doesn't make a big difference, private or public, but still, people like to start with private and move to public. Private company means closely held. Though, of course, even a public company can be closely held. We'll see the difference. Don't worry, we'll see the difference between private and public. Right? Now, both private or public can be limited by shares or limited by guarantee or unlimited. Both. You can have a private company limited by shares, limited by guarantee or unlimited. Similarly, public company limited by shares, limited by guarantee or unlimited. Now, if it is limited by guarantee or unlimited, it can have share capital or without share capital. With or without share capital. What is the meaning of limited by guarantee? We will see very shortly. Shares, etc. We will see very shortly. Don't worry. I will cover this. Especially what is the meaning of this? Don't worry. I will cover. Not now. Abhi nahi. Baat. Thodi si der baat. I will cover. Why? Because this needs to be explained very slowly and carefully. Fundamental principle. What is? Because liability, there is a limited liability. What is that limited liability? I have to explain to you. At the time, I will explain to you limited by shares, limited by guarantee, blah, blah, blah. Don't worry about that. Okay. It will be my unfortunate or fortunate duty to explain to you. Okay. Don't worry. Right now, let's go to section 3. To an extent, I'm trying to follow the study material. The minimum number of persons, okay, required to form these companies. Okay. We saw this. Let me refer this. Okay. And what is this OPC? OPC, meaning one person, not oil producing countries. Okay. One person company. That is a company which has only single member, one person can be a member. Okay. That is called OPC. Technically, OPC is a private company. Please, yaad rakh dijiye, humble request. Please remember this. Technically, theoretically, for the Companies Act purpose, OPC is a private company. Okay. So the minimum number of persons required for forming a public company is 7 or more. 7 or more. Minimum 7 or more. Minimum 7. Okay. 2 or more in the case of private company. 1 person in case of OPC. 1 person company can have only 1 member. No problem. More about OPC in this class itself I'll cover. OPC very important from exam point of view. So we will cover in deep. So 7 or more. Why 7? Why did they hit on this number 7? Any idea? Why 7? Just let us see. Why 7? Why this peculiar number 7? 7 or more in case of public company. Let us wait for your answers. In the meantime, I'll proceed. I'll not wait for your answers. But if you have any thoughts, do share. Why 7? Agreed. More person to catch hold in case of fraud, then why not 15? Why not 10? Or why not 5? Why this peculiar number 7? Actually, the answer is there is no actually right answer. There is no right answer. In fact, any answer is good enough, but your answer is correct. More person to catch hold, Mr. Malik. But why 7? Why not 15? Or why 15? Why not 5? Why not 3? Okay. Actually, there's no real India, there is no meaning for 7, but what you should understand is Indian law in 56. Yeah, let us see if anybody has any correct answer. Lucky number. No. It is not a lucky number. Lucky number for what? Moreover, sir, CEO is need not be a member, sir. Only he need not even be a director. CEO is a key managerial personnel. Don't confuse. Members will not play any role in day-to-day management. Members will not play any role in management. So you cannot have members becoming CEO and all that. Okay, so no, of course, your answers are not. See, you are giving me examples of 7 days in a week, 7 continents. In fact, we say Saptadvipa Vasundara. Saptadvipa Vasundara. Even in those days, in our own culture, we were aware that the entire globe consists of 7 continents, Dvipa, which are surrounded by sea. Saptadvipa Vasundara. So the Vasundara means the whole world. So we said Saptadvipa Vasundara, with 7 continents, 7 days in a week. Like that's Sapta Rishi. We have Sapta Kannika, Sapta Dham. We have Sapta Dham. We have 7 holy cities. Okay, and all 7. 7 is a holy number. 7 is a sacred number, not only in our culture, in many cultures across the world. 7, which is why the draftsman of the English Companies Act 1948, when he needed a number, he selected a number which was a number that he was familiar with. That's all I can say. 7 was a number he was familiar with. The draftsman of the Companies Act was a man for whom 7 had a significance. Therefore, he said 7 numbers. Because there are other organizations where he would have been a member, where they would keep on insisting 7 to make it perfect, 7 to make it perfect, or like that. So he will know that 7 is important. Therefore, 48 Companies Act, 7. Automatically, we copied in India 7. For us in 56 Act, we didn't think why 7. Gora has told 7, we will put 7. Why we should not put 7? We will also put 7 only. So we put 7. But it so happens in Indian culture also, 7 is a very mystic number. 7 is a mystic number. Okay. This for your information. This information will not be useful to you in the examination, but it is an interesting factoid that you might review, that you might like to keep in mind. Okay. Correct. Many of you are giving reasons. They are all correct. But technically, there is no real thing. Except that 48 Act has 7. Therefore, 56 Act has 7. Therefore, 2013 Act has 7. So that sequence is clear. How 7 came here from 48 Act. 56 Act, 56, 48. How it came to 48 Act and how it came to Societies Registration Act. Indians, the Societies Act also 7 or more. That is because the Britishers who were then drafting the law were members of organization for where 7 was a very mystical and important number. 7 or more was mystical or important. 7 or more. Actually, it is not 7. It is not exact 7 or more. Okay. Wonderful. Now we move on to the next important topic, which could come in the exam also. Yeah. Why 1862 was subsequent 1948 Act was the amended law. There also 7, right? As you say, it goes all the way back. Okay. Of course, you can look at many examples of 7 in this world. 7 seems to be some sacred number. So, now coming to the point. This is a very interesting section 3A, not relevant from a day-to-day company law perspective, but relevant from the exam point of view. Okay, in day-to-day company law, administration or advising your company, rarely you will have this problem where the number of members is falling below the statutory minimum. We saw the statutory minimum, 3. Now 3A says the members will become severally liable. That is, severally liable means individually liable for the entire amount. You might have heard this term in Partnership Act. The members are jointly and severally liable. Jointly liable, but also severally. That means individually. Suppose the firm owes the creditor 5 lakhs. There are 5 partners. Now, you cannot say each partner owes 1 lakh. No. Under the Partnership Act, the partners are jointly and severally liable. So the creditor can proceed against any one partner and can collect the entire 5 lakhs. Because the partners are severally liable. Of course, since they are jointly liable, that partner who was paid can sue the other partners and recover the amount. Because they are jointly liable. So his share is only 1 lakh. Balance he can take from the rest. Okay. So that is under the Partnership Act. Here, members are not liable at all. Friends, liability of member in a company is limited. So normally, if the company is having huge debt, the debts are more than the assets. Normally, you have invested in a company. You invested 50,000 rupees in a company, fully paid 50,000 given. Company was run by idiots. It kept doing losses. Finally, company is now insolvent. Means what? The liabilities are more than the asset. Right? Now, are you liable in any way? You are a member. Are you liable in any way? No, because your liability is limited to the amount, if any, unpaid on your share. Fully paid share, everything paid. What's your problem? No liability, normally. But if these 3 conditions are satisfied or fulfilled, then every member will become severally liable. So what are the 3 conditions? First condition, the number of members shall fall below the statutory minimum. That is to say, below 7 or 2. 2 in the case of private, 7 in the case of public. Okay, right. So the number of members shall fall below the statutory minimum. First condition. So you have to ask, did the number of members fall below the statutory minimum? Yes. The company should carry on business for more than 6 months after the number is so reduced. Company should carry on business for more than 6 months after the number is so reduced. Please note, Your Honors, after. So, number is reduced from that date. From that date, I have to carry on for more than 6 months after the number, right? So, number is reduced below the statutory minimum. Iske baad 6 months. Then after 6 months, if the company is continued to be run, then those members who are aware, cognizant means aware. Remaining members should be cognizant. Cognizant is a very complex Shashi Tharoor word for aware. See, I'm sure you heard of Mr. Shashi Tharoor. Even the simplest things he can tell in very complicated English. He likes to use, even I like to use complicated words, but not in my lectures. When I'm drafting, when I'm writing an essay for some intellectual groups, there I use very big words. Because my goal is, hey, you should be impressed me. See how much English I know like that. But here with students, I don't have to. But in the Companies Act, they're using the word cognizant. Cognizant means the remaining members should be aware of this. Boss, there is something called being aware and not being aware. Mujhe nahi malum, I didn't know this. Then it is over. You are not aware. But if you are aware and carry on the business beyond 6 months, please, number falls below the statutory minimum, then 6 months. During that 6 months, no liability. During that 6 months, no liability. 6 months ke baad, after that, the company is continuing to be run with the reduced number. Those members who are aware, cognizant of this, and carry on the business beyond 6 months, then those remaining members who are aware shall be severally liable for the payment of the whole debts of the company contracted during the time it carries on business after 6 months. So in that 6 months time is a grace period. Why it's given? See, I gave one example now. If all the members dies, be careful. It could be hit by 3A. If all the members die, the company continues to exist, no doubt. But you will be hit by 3A because the number of members has fallen below the statutory minimum. Are you able to understand? Therefore, within 6 months, you should ensure that the legal heirs are made members. The shares are transmitted. That 6 months is given. The shares should be transmitted to the legal heirs, and the legal heir should become the member. That can happen in 6 months. So that after that, within that 6 months, if you make up the number, no problem. But if beyond that 6 months, you are continuing, then the remaining members, okay, will become liable, shall be liable for the payment of the whole debts of the company contracted during the time it carries on business after 6 months and may be severally sued therefore. Okay. There will be one assignment I will upload. Now, in that assignment, let us see if you can do it. Here, there is a question. You can read it and give your answer. In the meantime, some queries are there. Let us see. Correct. He teaches English to Englishmen. Correct. It's a great now. Great that we are using the language of the British to hit them, to beat them. Okay, with their own language, we are insulting them. Correct, Mr. Porto Das. Liabilities for company, not member. Absolutely correct. No liability for member unless they fall in this trap. Okay. Now you read this Amar Akbar Antony and give me that. Give me your answer. Very cinematic story, yeah? Like Thug Life. Umar Akbar Antony, along with 5 of their friends, were members of Harmony. My God, Harmony means good relationship. But here they are all fighting. So possibly they went to a bar where, in a fit of anger, Amar killed Antony and Akbar on 18th August 2022. Hence, the number of members reduced to 6. How 6? Amar plus 5 others. 6. And the 6 members were aware of it. They continued operations without increasing the number. In March 23, the company took a loan for business purpose and defaulted in repayment. Okay. Now, all you need to do is first question. Yeah, let us see what answers I've got. Yes, 3A is one example where you cannot say members' liability will be unlimited. Yeah, it is a case where member will become liable for the debts of the company. Normally, the member is not liable. There is a limitation on the member's liability. Okay, but in case the member, if this condition, then the member will become personally liable. Personally liable. You can say unlimited, or you can say, yeah, unlimited. Okay. That is, the personal assets of the member can be attached for debts of the company. Agreed. Unlimited liability, sir. No limitation. Provided 3A conditions are satisfied. Correct. Correct. Okay. So, 3 conditions you have to see. First condition, was the number of members reduced below 7? Because it is a public company, Harmony Limited. Was it reduced below the 7? Yes. Did they continue for more than 6 months? So 18th August 22. Thereafter count 6 months. September, October, November, December, January, February. February 17th, 2023, 6 months got over. After 6 months, the remaining members who are aware about it have borrowed money from the bank. Now, the lender of that loan can sue the company or Amar or any of the remaining members, because such members shall be severally liable for the repayment of the said loan. Okay. That is the correct answer. They are all liable. They are severally liable. Please remember the word severally liable. Severally liable. Okay. They are severally liable. Okay. Good question. It's a good question asked by Mr. Anubhav Malik, which is, had they paid the loan and not defaulted, would penalty have arisen? Yes, there is a penalty also at the end of this chapter. For any violation under this chapter, okay, there will be a penalty. Okay, but personal liability won't be there. But there will be a penalty. Question is very good question. To answer it, yes, there will be a penalty also. Okay. Also, later on, if it's not in your syllabus, I don't know. It will come in maybe final. I don't know. Insolvency and what is that? Bankruptcy Code of India, where this is one of the Companies Act itself, compulsory winding up. This is one of the grounds on which the company can be wound up. Where the number of members falls below the statutory minimum, the company can be wound up by the tribunal. Compulsorily wound up by the tribunal. Okay. Good question, but Mr. Malik. Okay. Now we move on to incorporation. See, if you are raising the hand, I don't know what to do. Maybe unmute yourself and ask. That's all. If somebody has raised the hand, they can unmute themselves and ask any question. If all members die, then who will be liable? Legal heirs will become liable. Okay, provided they carry on the business knowingly. Gunjan Devi, they should carry on the business knowingly. See, let us say that all of the members die. Legal heirs are not carrying on any business. They are not doing anything. Then no problem. Only if they carry on beyond 6 months, they die. Okay. Yeah, then Ms. Riddhiben Rabari, you have to ask a question in the query pad or in this chart. You have to type out the question, please. Then I will read it and I will tell you. Okay. Under section 3A, all remaining members are personally liable for the company's debts incurred during the period when, no, see, for 6 months, there's a grace period. Only after 6 months. Okay. Only after 6 months, if they incur any debt, that they'll become personal liable. Within 6 months, any debts are occurring, then that will not be. If any liabilities accrue in 6 months, then the debt member, no, reduce below the minimum number 6 months. 6 months ke baad. Within 6 months, no. Beyond 6 months, yes. Company member can sue company also. The lender can sue company or any member. See, you will choose which is convenient. You sue everybody. Why are you? You got the right to sue them also. You can sue the company also. Company is the basic borrower. You can sue. In addition to that, you can sue them also. You got the point. It's not that company is not liable. Company is primarily liable. In case the company doesn't pay or if the company fails to pay, you can go to the individual members. If I were these people, the lender, I would, if you are the lender, first thing you have to be very careful. Find out if the statutory number is maintained. Don't lend. But if you still lend, this is protection for the unwary creditor. Okay, is the point. Okay. Now, incorporation is the process by which a company comes into existence through a process of law. The company comes into existence through a process of law. These are the steps. First, you have to reserve the name. Normally, when a person is born, at a particular time, there will be Namakaranam. Suppose my father wanted to call me Srikant. Now, they can call me. There may be 100 other people with the same name. No problem. But if it is a company, you can. Two companies cannot be formed with identical or resembling names. More about it when we come to name clause in the memorandum. But right now, remember, two companies cannot have same name or even resembling name. If they sound similar, also no. For example, Sony, S-O-N-Y, Sony. S-O-N-I is a surname in North India. S-O-N-I. S-O-N-I. Sony is a South India, is a surname. Similarly, S-O-N-Y is a Japanese brand. Okay. So, S-O-N-Y, S-O-N-I, if they are same name, that can be rejected. If you apply for a company, Sony Corporation, S-O-N-I, they will reject because there's already existing company called Sony Corporation in India. Okay. So, like that, they can reject. More about it when we come to name. First thing is you have to get the name reserved. First thing, they should say, yes, this name is okay. Then you have to prepare the memorandum and articles. MOA means Memorandum of Association. AOA means Articles of Association. I will be abbreviating MOA and AOA. Memorandum and Articles. Very important documents which are for in connection with a company. The memorandum, later on we'll be seeing the memorandum, which is the charter, and the articles, which is the bylaws or the rules and regulations. You might have studied it in +2 also. This is not something very complicated topic. So I'm little fast, we'll go. So these documents are to be e-filed and e-stamped. Now everything is digital. The Ministry of Corporate Affairs is totally digital. Okay. And in case any directors are mentioned in the memorandum and the articles of association, they have to give their consent. And that also should be submitted electronically by using their digital signature. Digital signature certificates are to be used to upload it digitally. Everything should be uploaded digitally. And then submission of statutory declaration that all the requirements of the Companies Act have been complied with. Once you file all this, pay the fees, which is based on the authorized capital. Authorized capital is the amount mentioned in the memorandum as the amount, number of shares up to which you can issue shares. Maximum number up to which you can issue shares is called authorized capital. Based on that, you have to pay fees, stamp duty under the state law, and you have to obtain the certificate of incorporation, which will be digitally signed by the registrar. And you have to file the declaration about the address of registered office within 30 days. Within 30 days, you have to file declaration of registered office. If you do all this, the 7th point is not along with 6. Up to 5 happens now. Then the certificate of incorporation is given. From that date, within 30 days, you have to file a declaration about the address of the registered office. Right? They give you 30 days to locate a place and enter into it. Because earlier we had a problem. See, before the company comes into existence, how I can enter into a lease agreement? We're able to understand. Company is not yet incorporated. Which landlord will give lease agreement? Yeah. And how I will get, and these idiots will ask me for lease agreement. I'm sorry to use the word idiot, but what in those days? Now they have also become a little sensible. They said, okay, you form the company, then locate a property. Then, now that the company is incorporated, enter into a lease agreement, upload it. Along with the proof of address, you upload it. Okay. These are the forms that you have to use. Okay. They have, see, the current government loves abbreviations. anything and everything, not only that abbreviation, the abbreviation should be a word. And that word also should be attractive word. They spend a lot of time in that. Okay, that's all I can say. They spend a lot of time in creating abbreviations. They love abbreviations. So this abbreviation was created in 2014, SPICE. Okay, those of you who are familiar with the Dune, universe will know what is SPICE. Okay, very important thing in Dune universe. Dune, by Frank Herbert. It also became a very popular two-part movie recently, Dune. So, SPICE. What is SPICE? Simplified pro forma for incorporating company electronically. SPICE. SPICE. Welcome to abbreviation world. Welcome to the world of this government with only abbreviation. They can't talk in full sentences. They like only abbreviation. So SPICE is a nice form. But again, having said all this critically, I assure you SPICE is good because you see, if a person has to become a director of a company, he should have what is known as a DIN. If Mr. A is to be appointed as director in your company, A should have a DIN. Means director identification number. Sorry, everything is abbreviation. MCA world is an abbreviation world. They don't like to give full form. If they give full form, they'll die. Everything abbreviate. Okay. So I think there is a separate department in the ministry whose only job is cooking up abbreviations. Not only for this department, everywhere I think the government will have there one or two fellows whose job will be only abbreviation. So SPICE. See, so if you want to have Mr. A as a director, he should have a DIN. Now, in many cases, first time people who are forming company for the first time, they may not have DIN. So when they come to us for incorporation, first thing I'll ask, so Mr. So-and-so, you want to form a company? Yes, sir. Who will be the director, sir? I will be director, sir. Okay. Who else will be director? My wife will be director, sir. Okay. Do you have DIN? Yes, sir. DIN? No, I don't have. What to do? Modi ji gives the answer very clearly and he says, don't worry. If you want DIN, along with the incorporation form itself, you can apply for 3 DINs. Wow. So happy. The SPICE form is a combined form where I can apply for name, I can apply, incorporate the company, and also I can get DIN for directors. Up to 3 directors, I can get DIN. It's a combined form. Simplified pro forma for him. So one shot, the Aam Aadmi comes, I want to form company, what to do? Okay. Then SPICE. Okay, go on. So this is basically SPICE form. You do not have to know the content of the form. This is enough if you know the name of the form. Okay. And form number INC 32, right? Which has to be filed. So now memorandum in form number INC 33. You might ask me, sir, what is INC? Simple. What is the name of this chapter? Chapter 2, na? What is the name? It is incorporation of company and matters incidental thereto. They've removed all that. Only incorporation. First 3 letters, INC. That becomes the form. Later on, when you come to prospectus and allotment of securities, you will find PAS. Okay. Abbreviation, kings and queens, yeah. Whether that law is implementable, whether that online uploading is easy, whether the portal is working, that we don't care. We will give you abbreviation. Okay. So the memorandum, that is EMOA, Electronic Memorandum of Association, EMOA. MOA already you know. That's why I'm also boldly abbreviating everything. Yatha Raja, Tatha Praja. So when the Prime Minister likes to abbreviate, it's called citizen. Why I cannot abbreviate? So MOA, EMOA means Electronic Memorandum of Association in form number INC 33. And electronic article. Articles of association is the rules and regulations. Memorandum is the charter. Okay. Now, just to give you comparison, the partnership deed is a combination of MOA and AOA. It is a charter which brings the partnership into existence and also the rules and regulations which are contained in the deed. So the partnership deed or partnership agreement is a combination of MOA and AOA. Whereas here they are alag. For company, they are saying separate. Memorandum is charter document. It is to be formed in form number INC 33. Articles EAOA in form number INC 34. Okay. So this should also be furnished and should be signed by all the subscribers by hand. Okay. And then upload it. In case you want to use the e-form, then digital signature. All of them have to sign digitally. Witness also should sign. Each subscriber shall add his name, address, if any, in the presence of at least one witness who shall attest the signature, sign, and add his name. So technically, it should be signed, and then scanned and uploaded. Okay. Now, they also want to clarify, because India is a country where there are a lot of people who are still illiterate. See, my dear friends, don't think that this name, signature, address, etc. should be in English. It can be in the local language, whichever language it is. Malayalam, Telugu, Odia, maybe Hindi, whatever. It can be in whichever language. India has so many languages. Am I correct or not? We are 23, I think, officially 23, I don't know, maybe more than that, languages. And it's a huge country. Okay. But it has only 2 official languages. Okay. The Rashtra Bhasha, we have 23. All of them are national language. The official language, only 2. Okay. Only 2. One is Hindi, the other is official language of this country. It's not Hindi, it is English and Hindi. Okay. English is also a official language of the government of India, central government and state government. Every state government has its own state language along with English. Central government, Hindi along with English. State government need not use Hindi. They use their local language along with English. So in all cases, English is the Rajya Bhasha. It is the language of the government of India. Okay, all documents which are in Hindi should also be in English. And in the states, all forms which are in the local language vernacular should also be in English. Okay. So my point is this signature, etc., need not be in English. It can be in vernacular, local language. But be careful. If that person is signing it in the local language and the memorandum is in English, then the witness should also write, it was read out and translated and understood by the signatory to the memorandum. I have done it many times. Elderly people will come. They may not know English. They know the local language, Telugu or Malayalam or Tamil or whatever. Then I will sign. I'll just ask them, Madam, have you understood what you're doing? Yes. Whatever. I won't ask in English. I will ask in their local language. And then I will, as witness, I will ask the witness to say, read out and translation was read out and understood by the signatory. Very important. If it is not being signed in English, or if the memorandum is in English, person is not signing in English. Can the memorandum be in Hindi? Definitely, why not? Nothing wrong in it being in Hindi. Okay. So where the subscriber is illiterate, then thumb impression or mark. Okay. And you should write thumb impression of so and so. Okay. You can affix this thumb. Usually right thumb will be affixed. Okay. Where the subscriber is a body corporate, then the memorandum will be signed by a director, officer, or employee. But that person should be authorized by a resolution of the board of directors. And that should also be kept. Okay, that is, if your company cannot sign now, it is an artificial person. So company is becoming a subscriber to the memorandum. Okay, in which case, how can the company sign? Where is the hand? Company is an artificial person. Therefore, on behalf of the company, director or an officer like CFO or CEO or employee can sign, provided that person is authorized by a board resolution. Okay, that person it is very important. The person so authorized shall not at the same time be a subscriber to the memorandum. Means he cannot sign in both places. A for and on behalf of ABC Limited and A as himself. Some other person should be the other subscriber, right? I'll just finish this and take all your questions. Whereas a limited liability partnership, it can be signed by a partner who is duly authorized by a resolution. Same logic here also. The person signing on behalf of the LLP cannot also become a subscriber to the memorandum. Okay. If you are a foreign national, then very difficult, sir. I have easily incorporated about 50 companies wherein the members are from outside of India, foreigners. Very difficult, sir. Whenever they come to me, I tell them, boss, it's going to take time because you come to India and sign. That is the best thing for me. Wherever, whichever country you are, please come to India. It's a Karma Bhumi. It's a beautiful country. Come here, sit in my office and sign, no problem. I will witness it for you. But if you're signing it in Canada, if you're signing it in US, then it has to be witnessed there. Also, it has to be notarized by a notary public. Okay. And if that person is residing outside the Commonwealth, which is not an apostille convention, then the diplomatic or consular officer should attest it. If it is within the apostille convention, then it has to be apostilled. A-P-O-S-T-I-L-L-E-D, apostille. Sir, first of all, an advocate should sign, notary. That is, A is signing the memorandum, B is signing the memorandum, then witness, then all of them go to the advocate. And the advocate will notarize it. And then there will be another official who will confirm that, or the Indian embassy has to confirm that this person is a valid notary public. That is called apostilling. Got it? With all that document, it has to come to India. Takes a lot of time. And the minute these guys come, I tell them, boss, I'm undertaking this assignment, but minimum 1.5 months. Oh, why? We thought Modi ji told us we can incorporate a company day after tomorrow. Yes, you can. Sign here now. If you go back and sign, apostilling, it will take, not because of our country, your country ka problem. It has to, see, for example, if a guy is sitting in Minnesota or if he's sitting somewhere in Atlanta, fellow has to go to Washington, yeah. Or he has to go to New York, where our embassy is there, and get it apostilled. Seriously, it's not easy, okay? Or Los Angeles. Only these 4 or 5 cities in US have Indian embassy. To my knowledge, Los Angeles has, Washington has, New York has, that's all. You have to go there and get it. Maybe in Texas, maybe you might have Dallas, maybe. Depends. Okay. Foreign national residing outside India and has visited India. In such a case, if she is or he is having a business visa, in case person of Indian origin or an overseas citizen, requirement of business visa, that's what I say. You come to India, no problem. You sign here, absolutely no problem. I will witness it for you, or I'll get a witness for you, no problem. Come here and sign. The minute you say you're going to sit there and sign, it will take a lot of time. That's all I can say. Because I'm talking out of experience and practical knowledge, not out of any other things. Okay. This, once you are incorporated, you will get a SIN. Okay. SIN is company identification number, not SIN. That is what I have committed in the past. All my sins. Okay. All the bad deeds that I have done are called SIN. Am I correct? Whereas this is SIN, CIN, company identification number. For example, in the institute material, you will find the SIN of Infosys Limited, which is expanded in this way. L is the first character, means it is listed. If it is unlisted, U. Infosys is a listed. Next 5 digits is the company number 85110. Okay. Then the next 2 letters reveals the KA. KA is Karnataka, which is incorporated in Bengaluru, which is the state of Karnataka. Then 4 digits, 1981, year of incorporation. Next 3 PLC, whether it is public, PTC for private, FTC for foreign, GOI for government. Okay. Last 6 digit is the registration number with the ROC. So technically 013115 is the registration number of the ROC. Okay. So this is how it is done. In addition to all these documents, you have to file INC 8, which is a declaration given by an advocate or CA or cost accountant or company secretary in practice. or by a person named in the articles as director, manager, or secretary, that all the requirements of this act and the rules made thereunder have been complied with. Normally, I will not sign it. There was a time in the past when I started my practice in 1991, because I was young and energetic and enthusiastic, I used to sign. Thereafter, 2000 onwards, nearing about 2005 onwards, 2002 itself, I said, no, I will not witness, I will not sign. In those days, Form 1. I will not sign Form 1. See, one of you directors, you sign, get your own witness. I won't, because I found a lot of problems because I signed witness, even including CBI inquiry. So I said, no, my name won't come there. Okay, still there are some very old articles of memorandum of old clients who are now with me for 30 years. They will proudly show my signature and say, you sign. And there's a special case when the promoter is a well-known person to me, whom I trust and I have 100% confidence. And I said, more as a luck. Sometimes they say, Shrikant, if you sign, when you sign as witness, those companies have prospered. Please, there's a sentiment you sign. Then as a special gesture, I will sign. Otherwise, no, I will never sign witness or sign for my sake. Okay. For some VIP clients, I sign. That too when they request. So I've got to sign as a, sometimes they think it is a luck. Also, INC 9 from subscriber list memorandum and first directors that all the documents contain correct and complete information about him. He is not convicted of any offense or he has not been found guilty of any fraud, etc. Okay, so this is what is there. So these are all particulars that have to be given here. Nothing important. This is not important. Okay, not important. Also, you have to give the particulars of the interest of the persons mentioned in the articles as the first director in other firms or bodies corporate. This may not be relevant to you now, but this link will come later when you go to final. There you will talk about contracts in which directors are interested and companies in which directors are interested. Okay, this list is given now so that the company will be put on notice by the director. At the time of incorporation itself, he has to say, I am director of Dubakur Limited. My wife is also a director. I am shareholder in Manar and Company Limited. All that you have to give. So that later on, if this company is going to enter into a contract with that company, it's a contract in which director is interested. Therefore, at the time of incorporation, you have to mention the other companies in which you are a director, other firms in which you are a partner, other companies in which you are a shareholder. Complete list that to be given. Okay. Chalo. Now at this stage, let me see what are your questions. Yes, liability may be company, any one member, or all the members. Severally liable. Correct. You are absolutely correct. Okay. Yeah. Okay. Under the old law also, there was actually SPICE was there even under the old law. SPICE is not 2013. I think it is even before that. SPICE was not there, but online was there. And even under the old law, DIN was there. That is why when the new law was formed, there again they introduced DIN. They said all the DIN allotted under the old law is still valid. Any DIN which has been applied and allotted in the old law is still valid. Yeah, there was a DIN, but form was there, procedure was there. Okay, is the fine. Notary is a lawyer who is licensed to certify documents. So the notary's job is he will see the document, content of the document, and then the signature will be done in his presence. And then he will notarize and say, these people have appeared before me and I have signed in my presence. So that way, that signature is authenticated. Witness also will be there. In addition to that, the notary will give more legal validity. When a document is notarized, notary is done on stamp paper usually. Mostly agreements are only notarized, which will be, see, notary and stamping has nothing to do with each other. You can take any document and get it notarized. For example, promissory notes can be notarized. But usually documents which are to be registered are notarized, or documents which have legal implication will be on stamp paper. Only they will be notarized. So don't think that if it is to be notarized, it has to be on stamp paper. No. But usually stamp paper documents only will be notarized. In this case, memorandum and articles are stamped documents. There is a stamp duty under every state law, stamp act, there is a duty. Okay. So, good. I hope all the questions have been answered. Now, what I thought I will do is, I will finish to here and I will give a break. Okay. So, issue of certificate of incorporation on registration. And sometimes I'm going fast because this is not very important from exam point of view. 1, 2, you can read from the book. I'm only repeating. Once the company is incorporated, we will issue certificate of incorporation. Okay. A SIN will be allotted. Okay. All the documents connected with incorporation of the company, everything which is filed at the time of incorporation should be kept. There is no time limit. It should be retained by the company till its dissolution permanently. Okay. Everything which was in all subsequent amendment, everything completely should be maintained by the company at its registered office till its dissolution under this act. Later on, when you come to accounts of companies, we will see you can preserve the books of account and papers for 8 years. Books and papers for 8 years under the Companies Act. But here, these documents which are connected with incorporation should be maintained and preserved till dissolution, right? Now, in the course of incorporation, if you furnish false or incorrect particulars or knowingly suppress material information, for example, one of the directors has been convicted and not eligible to be a director, you suppress that material information at the time of filing papers, you don't mention it. Though you are supposed to mention it. Am I correct? You have to mention. You don't mention it. Whatever it is an offense. And the person furnishing such wrong information or suppressed information. In case at the time of incorporation, suppose a company already incorporated, it has been incorporated. See, false information has been given. Company is in the process of being incorporated. It is during incorporation. False information was provided based on which the company has been incorporated. Company has already been incorporated. Then the promoters named as the first directors of the company and the persons making declaration. And in the case of company under incorporation, the persons furnishing that information, they shall be liable for action under fraud under section 447. See, section 447 is not in your syllabus, but 447, maybe if you are studying prospectus and allotment of securities, you may go through it. And I will, maybe if I'm covering, I'll cover it or somebody will cover. Because there, 447 is there. 447 is a very powerful section. For any fraud or misstatement, etc., then imprisonment will be there. Up to 10 years and all imprisonment. To minimum 3 years, so on and so forth. It's a very tough section. Okay? But not in your syllabus, but better to know it. Now, if a company is under incorporation, obviously, the registrar will stop the incorporation process. Once they discover that it is false, then they will take penal action against the person. So this route, no problem. Suppose it has already been incorporated by providing false information, already incorporated, then what are the orders that the tribunal may pass? Okay, it can pass suitable orders for regulation of the management of the company in public interest. After all, if these people are giving false information, then they are fraudulent people. Therefore, the tribunal, on an application made to it by the central government, may pass an order that so and so will not be the director. They may appoint some responsible people, some IAS officers to control the company in public interest or in the interest of the company and its members and creditors. Also, they can amend the MOA or AOA, etc. This is one power, which means the company will be allowed to live, but under new management, till that some of the shareholders who are genuine, they can elect themselves as directors and run the company. That is one thing. Another power, the tribunal may direct that liability of the members shall be unlimited, which means what? You gave false information, no. So you will not get the protection of limited liability. Whatever borrowings the company has made, directors and the members have to become liable, unlimited. Whatever may be the amount of debt, the creditor can sue both the members severally and also the same effect as 3A. Same effect as 3A. Direct removal of the name of the company from the register. Suppose company has been incorporated, false information provided, company incorporated, nothing has happened, still things are in a flux. Then straight away they can say, what did we do? We brought you into existence by entering your name in the register. I will remove your name. That's all. Get out. Matter over. Company will cease to exist. Or in case the company has already started functioning, they can say wind up the company. Winding up means the assets will be sold and the liabilities will be paid. Suppose bank balance is there, they will freeze the bank account and appoint a liquidator. Liquidator will take the money and pay the creditors and the shareholders, if any, and close. That's all. Wind up. Okay. Pass such other orders as it may deem fit. That's why they're giving other orders. Like, for example, I told you now, suppose they have collected money, borrowed money, that money is lying in the bank. To prevent further fraud, the tribunal can pass an order saying, directing the banker not to allow operation of the account. No withdrawals, maybe deposit, but no withdrawals. So that that money can be used only for payment of creditors and repayment of capital. Okay. But before passing an order, the company shall be given a reasonable opportunity of being heard. This reasonable opportunity is a very powerful word. Because in a democratic country, even if the person was caught red-handed while committing a crime, he should be given a reasonable opportunity of being heard. Okay? And whatever he wants to say in his own defense, you have to listen, you have to record. And then you can take a decision and say, we do not agree. So tribunal should take into consideration the transactions, etc., before passing any of these. That's okay. Now, incorporation is one step in that, but that is not enough. Suppose you have incorporated a company, right? Then the company has to open a bank account. Then it has to deposit the subscriber to the memorandum against their name. They would have agreed to take up a certain number of shares. So, suppose I have agreed to take 100, you have agreed to take 100. Per share value 10 rupees. Then I have to give 1,000, you have to give 1,000. Now we have to open a bank account and and you have to deposit 2,000 rupees. Are you able to understand? That is our paid up capital. Whatever we promise to subscribe should be brought in within 30 days. Also, the registered office details should be given within 30 days. Got it? Then the registrar will issue commencement of business certificate. With that, you can operate the bank account, you are now in business. Till such time, you cannot. This is applicable to private company also. In those days, commencement of business was there only for public companies. Under the old law, only public company had commencement of business. Whereas now, whether public or private, you have commencement of business within 30 days. Okay. So a declaration is filed by a director within a period of 180 days of incorporation of the company with the registrar that every subscriber to the memorandum has paid the value of the shares agreed to be taken by him. And the company has filed with the registrar a verification of its registered office within 30 days. Now, usually we don't wait for 180 days because anyway, within 30 days, we have to give registration address, registered address. So what we do, we ask the promoters to open a bank account, deposit the money, give us the proof, also registered office address, lease agreement, everything we upload it. Then automatically the company will be eligible to commence its business. Okay. Also, it cannot borrow money until it has obtained the commencement of business certificate. Right. This is a very important aspect of incorporation, which many chartered accountants do not know. Okay. They think once they incorporate, that's it. Which is why many times clients come to me. You have been incorporated somewhere else, by some company secretary or somebody, they come to me and they then to take up the audit. The first thing I see is, boss, have you obtained the commencement of business certificate? Kya? What? I don't know. Oh, you should have been told. Who incorporated? Mr. XY. What to do? Luckily, if 180 days is not over, we quickly make them do it, file. Belatedly, we file this with apology and extra fees and all and close it and then start it. Okay. So many times, people come to us, we want to incorporate company, then we give them a quote, they get angry and they go. Later on, 2 months later, they come back, they say, no, sir, what you told is correct. It is not a one single thing, incorporate and go. There is so much we have to see. Okay. There is so much we have to advise. Provisions relating to commencement of business, if you have not complied, then penalty of 50,000 rupees. Or if the officer who is in default, director or MD, then 1,000 rupees of every day during which the default continues. That is, within 30 days, you have to file this. Within 180 days, that. So beyond that, you have to pay 1,000 rupees for every day during which the default, up to 1 lakh. For company penalty, 50,000 rupees. Better to avoid all that is the point. So we can stop here and we'll be moving to OPC. Today, I want to complete OPC and stop. My goal is to finish OPC and stop. Okay. So let us take a brief break. In the meantime, if you have any doubts, you can raise on the chat box. If the signature, question asked by Abhinav Mishra regarding company incorporation where subscriber is foreign national, should be notarized by Indian notary or by. See, you have to get it notarized by a local notary only. Indian notary, how he can notarize? Only foreign notary. But our Indian embassy should apostille it. You have to go to the Indian embassy. And there will be a separate section where the notary will give proof of his authority. Based on that, they will verify their register. They will give apostille certificate. Then this notary was eligible. But notary will be a foreign notary. Very complicated process, not easy, I'm telling you. Okay. Both are penalized, Mr. Malik. Company and every officer in default. Okay. Every officer. See, that is why Ministry of Corporate Affairs is a revenue generating ministry. That is why, it was earlier in the Ministry of Law and Justice. Then Finance Minister, Mr. Chidambaram, realized, hey, these fellows are collecting huge money. They should not be with the Ministry of Law and Justice. So the Department of Company Affairs came under the Ministry of Finance. Then finally, they gave them their own ministry status with the Minister of Corporate Affairs separately. But technically, their they will be controlled by the Ministry of Finance. Many cases, the Minister of Finance herself will be the Minister of Corporate Affairs also. She in this case will take both. Okay. So apostilling is an act by which the notary will be declared as genuine. That's all. See, the notary public is signing now. So our embassy in that country will tell, hey, this notary is a valid notary and he is eligible to sign. Because we don't know now who is notary, who is not. Suppose it's a forged document. Therefore, we go for apostilling, not apostle. Apostle in Christianity is one of the 12 disciples of Christ. There is an apostle. No, this is apostilling. It's an act, verb to apostile. That means to certify that the notary is correct, is valid notary, like that. Okay. Thank you. Now let's have a small break for about 5 to 10 minutes and then we will take up OPC, very important topic. Don't go away. Okay. Sir, small break, sir. Welcome back from your well-deserved break. Now, we move on to a very important topic from the exam point of view also. Well, see, from a practical perspective, I do not see OPC as a major issue because, see, in all my 38 years of practice now, okay, I started practicing in 1987. In all my 30, 35, 38 years of practice, maximum 4 OPCs out of OPC itself came only in the 2013 Act. So even post the new law, 13 to now, 23, you can say 25. So the 12 years, I've seen only very few OPC. Okay. But it was bought as a great measure because other countries have this concept we don't have. So one of the major goals of the current government is whatever America has, I should have. Whatever Europe has. Whether I need it or not, that is different. But I will form. So OPC. 1% companies can be formed. Rarely they have been formed by Indians. Invariably, they want to, only foreigners want to form it. Because they think that's something fun. They usually I get inquiry from US, man will come to India. So want to form a OPC, can I do that? So go ahead and form, yeah, what can I do? How can I prevent you from doing it? Go ahead. Okay. So there were in 2020, okay, during Corona, there were 34,235 OPCs out of a total of 1.3 million. That is 13 lakhs. 34. That's 3% of the companies are OPs. Today, the percentage might go up to 3.5. Because the number of companies is also going up now. The active companies is also going up. OPs also. OPs may not go that much. Okay. 35,000. But still, institute likes OPC. They like to ask question in OPC. So I'm covering OPC. Okay. In fact, many times people come to me and say, sir, I want to form OPC like that. Then I'll ask him, what is your ultimate goal? No, sir, I want to go public, IPO, blah, blah. I said, better go for private company, man. Because later on, you'll have to convert to a public company and then go for a public issue. Why all that? Now itself become private company. Simple. We can go on, just remove that, private become public company. Go on. Why OPC like that? So that is my view. Okay. Though later on, my team and my office staff also said, sir, after all, what is your problem, sir? Fellow comes, he wants to form OPC, let him form. We'll take the fees and enjoy. Why are you preventing? I said, okay. Then later on, if he wants to form a normal company, we'll form for him. Let's have some more money for us. Then only I realized better allow these flunkies to form an OPC, which will be anyway useless. Then they will say what to do. Then we'll close the OPC or keep that OPC, which means one more annual fee for us. And also form him a new company. All sorts of fun we can have with these people. OPC. I mean, sorry, that's my view. Okay. Boss, you can have a single person. Yeah, that's all. You can have a company wherein you are the only director and only shareholder. That's all. Okay. But it'll have the benefit of limited liability. That is the point. So you'll be the only shareholder, maybe even the only director. But it will have the benefit of limited liability. So that your liability will be limited. Right. So OPC means a company which has only one person as a member. The Memorandum of Association of an OPC shall indicate the name of the other person who shall, in the event of the subscriber's death or his incapacity to contract, become member of the company. Friends, what they are trying to do here is, see, there is only one person. Suppose that one person dies, what will happen? The number of members will become 0. That is not correct. Therefore, they say, at the time of incorporation of the company OPC, that single member should nominate a person who will become the member in the event of the subscriber's death or his incapacity. Means if he becomes insane, lunatic, or if he otherwise incapable. Okay. In those cases, the nominee will become the member. Are you able to understand? So there are two people. One in OPC, first the member, single. Then another person who is the nominee, who will become a member in the event of the death. So the prior written consent of such person, the nominee, should be obtained in form INC 3 should be filed with the ROC at the time of incorporation of the OPC, along with its MOA and AOA. Later on, when I show you the MOA and AOA format in the next class, I will show you how it will be for a OPC. For OPC, the subscriber will be there, and one more clause will be there, where we will say, in the event of death or incapacity of one of us, of me, donkey will become member. One more, they will nominate a person to become member in the event of subscriber. Got it? So two people. Also, OPC need not have only one director. OPC can have up to 15 directors, no problem. Single shareholder, but no restriction on directors. Just for your information. But why should we have it? Invariably, I am the shareholder. I am one director, no problem. Okay, no issues. Now, OPC, very important. I cannot overstress the importance of this point. Member should be, both member as well as nominee, should be a natural person who is an Indian citizen, whether resident in India or otherwise. So, whether resident in India or otherwise, therefore, we need not bother about residence rules. Earlier, they were bothering about resident, non-resident. Now they don't say. You want to form an OPC? Then two conditions. One, are you a natural person, living person, biological? Yes. Are you an Indian citizen, whether resident in India or otherwise? What they mean by resident in India is a person who has stayed in India for a period of not less than 120 days immediately preceding financial year is a resident in India for this section, but meaningless, because even if that person is not a resident, so long as he is a citizen of India, he can be a member of a OPC. But if such person is a citizen of a foreign country, they cannot be a member of OPC. I'm sorry to make this comment. Many times, our compatriots who have fled our country and have gone to other countries will come back and they want to form OPC. Okay, sir. They come. I want to form an OPC. Okay, form. I will ask only one question. Which country you are a citizen? Or rather, are you a citizen of India? Yes, I am a citizen of India. But I know that they are not. So I'll ask, friend, brother, sister, I'm asking again, are you a citizen of India? Yeah. I am a person of Indian origin. I'm not asking whether you are a person of Indian origin. Are you a citizen of India? No, Mr. Srikanth, I am an OCI. Did I ask you OCI? That OCI is only a card which will enter this country without a visa. You will not be treated as a foreigner. You will be given a straight entry into this country. Because it so happens, once upon a time, this country had the misfortune of having you born in this country. Therefore, you are a OCA, overseas citizen of India. But that doesn't make you my citizen. No. Then I will ask the $1 million question. $1 million question. My dear brother or sister, what passport, which country ka passport you are holding? Immediately, Australian passport, US passport, UK passport. So you are not a citizen of India. You are a citizen of UK. You are a citizen of US. You are a citizen of Canada. You are a citizen of Australia. I'm highly impressed by you, etc., etc. But don't ever in this life call yourself an Indian citizen. You are decided to deny it. You are decided to reject your mother country and become a citizen of a foreign country. No longer you can claim connection as a citizen of this country. Okay, I know I'm a bit rude, but fact. Think about it. And the $1 million clincher question is, which country ka passport you are holding? Okay, of course, OCI we are giving in India more as a consolation prize because these fellows invest some money in India, so we allow them to come and go whenever they want. That's all. We don't treat them as foreigners for entry into India. But other than that, they are not resident. You have to be very careful because many of these sections talk about Indian citizen. You have to be very careful, is that right? Okay, so that is the point. See, person of Indian origin is a person who, PY means what? Either parent or any of the grandparents were born in undivided India. Okay, POI, person of PIO, sorry, person of Indian origin. Okay, that is PIO, where person of Indian origin means what? Any of his parents, sorry, either of his parents or any of his grandparents. That means what? Parents will be two, mother, father. Grandparents, four. So any one grandparent out of the four, or parent, mother or father, was born in undivided India. That means when these laws were enacted in 1956, they wanted to be sure. See, person was born in Lahore, that was undivided India in those days. So they were also included. So grandfather might have been born in Lahore. So, or he might have been an Indian citizen, but Lahori, which means Lahore was at the time very much a part of India. Karachi, Lahore were all part of India, undivided India. So they are also PIO. Means they have gone there now. Mainly Punjabis who fled during the partition. Their grandparent would have been born in Pakistan. No Pakistan. Therefore, they say you are undivided India. So these are called person of Indian origin. Once upon a time, we had high regard for them and we were giving them VIP status. We were allowing them to come to India. We wanted their foreign exchange, etc. We fell at their feet. Today, neither they want to invest in India nor we want their money. Because we opened up the economy. Later on, when you study FEMA, you will understand. We really do not need these guys. We can handle on. India itself is a hugely developing economy, capable of, we are going to become a superpower in hardly another 10 years. When equal to or better than other countries. So why are we bothered about these people? Okay. Anubhavji, absolutely useless. That's what I'm telling. This 2013 Act is a beautifully foolish enactment. Why this class? Clearly you are saying whether resident in India or otherwise. Why again? So if you keep on asking me, I'll keep on telling this only. So please don't mistake me. Huh? If the person is citizen of India but not stayed more than 120 days in current year, anything, whether resident in India or otherwise, nothing. Parthodas, he stayed in India last year 120 days, more than 120 days, less than 120 days. No. Are you, at this point in time, when you want to form the OPC, are you a citizen of India? That's all. If you answer yes, form. Last year, whether you stayed 120 days, more or less, doesn't matter. But still, the section has these wordings. Therefore, I am giving it. But what is important is these words. These words. Whether or otherwise. So, okay. So that is how we have to understand. Don't worry. Only this part you understand, that is enough. Are you a citizen of India? Ask. Yes. Come. No, get out. So, okay. Suppose the nominee withdraws his consent by giving notice to the sole member. In that case, within 15 days, the sole member should nominate another person as nominee. Okay, within 15 days. And that should be sent to the company and also the register in form number INC 3. Okay. Now, the member can replace the nominee at any time. Earlier, the member had a person as nominee. Now changed. We can. Again, you have to give nomination intimation. Okay, in writing. Right? And any such change in the name of the person shall not be deemed to be an alteration of the memorandum. Why? Because in the original memorandum, the name of the first nominee will be mentioned. Now, because you're changing nominee, no need to amend the memorandum. It is enough if you file INC 3 with the written consent of the nominee in INC 3. That's all. Okay. Now, in case the sole member ceases to be member due to death or incapacity, then the nominee will become the new member. And once the nominee becomes the new member, that nominee should immediately nominate within 15 days another person who will become the. So nominee should also appoint. The nominee has now become member. You should. Got it? then in all the above cases, withdrawal of consent, replacement of nominee becomes member and a new nominee is appointed, whatever it may be, you should intimate to the registrar within 30 days in form number INC4. Okay, form number INC4, along with the prior consent of the nominee who is appointed. Okay, all the above notices and intimation shall be in writing. No specific form. See, this shall send an intimation and all. No specific form. Okay, when you want to replace, you simply send a letter saying to the company. You might ask me, sir, what is this company? Separate legal entity, Anna. Though one person company is still that one individual member is different, separate legal entity from the company. So that man will write a letter to the company, okay, at its registered office. Imagine, Srikanth, one person company. Dear board of directors, who is the board of director? I am the director. Dear director, to the director, Srikanth OPC, from Srikanth. What does it say? I have replaced Mr. Donkey, who was my nominee, with Mr. Monkey. Consent of Mr. Monkey in INC3 is enforced. Please note the change in your books. Then who will note it? He will have to note it myself. Or one company secretary will come, then he or she will note it. That's all. Okay. And then the company within 30 days has to file INC4. Earlier, Monkey was the nominee. Now, replaced by Donkey. Like that. Okay. Very, very important. Very, very important. A natural person shall not be a member of more than one OPC at any point of time. So you can be a member of only one OPC at a time. And you can be nominee of only one OPC. So at a time, a person can be a member in one OPC, nominee in another OPC. Now what happens? Suppose I am member of my OPC and also nominee in Mr. X OPC. I am a nominee there. X dies. Now what happens? I become a member of X OPC now. Because I am a nominee there, I become member. Now I am member in my OPC and also member there. Not possible. Where a natural person being a member in one OPC becomes member in another OPC by virtue of his being nominee, then such person shall meet eligibility criteria within a period of 180 days. Simply they have said, you decide, Baba, you can be in only one company. So are you going to be in your company or are you going to be there? So what I can do, if I want to continue in my OPC, I will sell my share to somebody, cease to be a member there, come here. Or you understand, the minute I become member, I have to appoint a nominee, right? Suppose I cannot cease except by selling. So I have to sell my share to somebody, cease to be a member. Okay, got it? Whatever it is, I am given 180 days to meet the eligibility criteria. So have you understood? A natural person shall not be a member. I don't know why they say natural, because natural person can only become member of OPC now. So such a natural person shall not be a member of more than one OPC at any point of time. At the same time, you cannot be in two. No, only one OPC. Also, you cannot be a nominee of more than one OPC. So in case you are a nominee in one OPC and member of your own OPC, where you are a nominee, that person dies, you will become member now. Not possible to be in two. So they give you 180 days. In 180 days time, you have to decide and continue in only one. Are you able to understand? No minor shall become a member or nominee of the OPC or can hold share with beneficial interest. So OPC minor cannot become member or nominee nor hold share with beneficial interest. Nothing. Because OPC itself single member, minor cannot enter into a contract. Why all this nonsense? So minor not possible. Though a minor can be a member of a normal company. Are you able to understand? Minor cannot be bound by his contract, but he can be a shareholder with beneficial interest without liability. Fully paid shares he can apply. So, for example, your father or uncle might have applied for shares when you are a minor. fully paid shares. Nothing wrong. You can be. But there if you are a minor, clearly you should mention who is the guardian. Till you attain majority, the guardian or parent only will have voting rights. Once you attain majority, you will take up the share in your own right. That is for a normal company. OPC minor cannot become member, shall not become member or nominee or hold shares with beneficial interest. Okay. Now, very, very important. See, these are all what I suggest now. I have already given you in short form only. But if you want to further extract it in a notebook, you can write. Natural person only can become member of OPC. Only citizen of India can become member of OPC, whether resident or otherwise. Then, every OPC should have a nominee. Person can be nominee in only, member in one company, only one OPC, nominee in only one OPC. Where person becomes member, because he is nominee of a company, within 180 days, he has to either be in only one. Got it? Like that, if you write now, you will never forget it. Similarly, OPC cannot be incorporated or converted into a company under Section 8. In the next class, very, very shortly, we'll be seeing Section 8. What is Section 8? Blah, blah, blah. We will see. But what you remember is OPC, Section 8 company is basically not for profit. Companies that are formed under the Companies Act, which are not for profit. I don't use the word charitable because maybe for social purpose also or whatever. So not for profit. That's much I will say. Their goal is not to make profit. You will see that when we conclude. Just for your immediate understanding. So OPC cannot be not for profit. Sometimes, Mr. Shrikant, I want to form OPC. Okay, form. I also want to do good to society. Okay, do. So I want this OPC to be a Section 8. No, not possible. You want to do some CSR, some charity work, form Section 8 company separately. OPC separate. Okay. Many times, many entrepreneurs, they say, I want to run the company for doing good to society. I say nonsense. The goal, I am a chartered accountant. You are going to become chartered accountant. Remember, the goal of your company is to maximize the wealth of the shareholders. That's all. Don't bother. If you want to do social service, go form a charitable trust. Go take sannyas and do work. Go become Swamiji. Go. Swamiji himself is having profit motive. Many of these Swamijis are having profit motive. Then where is the question of NP, not for profit? Therefore, see, you want to do good to society, good. Later on, maybe if I get the chance to teach you accounts, we do CSR, I will tell you more. Goal of a company cannot be to do charitable. Unless it is so, if you still want to have a company and you want to do charitable or social objectives, go for Section 8 company. Normal company, the goal is very clear to maximize the wealth of the shareholder. Obviously, to increase the profit, but ultimately, the wealth of the shareholder should be maximized. That is the goal. Any other goal, if anybody tells, I'll say it's bullshit. All other goals are subject to this one goal. Okay, corporate governance, this, that, all that is nice to talk. ESG, sustainability, all that is nice to talk. You don't make money and pay dividend, what happens? You tell me. Why I invested money in your company? For you to do charity? Yes, to an extent. Main goal, make money. That's why I gave you money. Okay. I know I'm being very blunt and rude, but don't lose sight of this. Okay, is what I would humbly submit. Those companies like Reliance, Maruti Suzuki, who are clear on maximizing shareholder wealth, have also done CSR, but their main goal is that. Okay. And that's why they become huge blue chip companies. They also do CSR. But the minute you say, I want to do public service, then why did you form a company? Become Swamiji, go form an ashram, go. Form a Section 8 company, become Swamiji, go. Okay. So, though it may be converted to private or public companies in certain cases. So, you cannot convert or incorporate an OPC or convert an OPC into a Section 8 company. But an OPC can be converted into private or public company. Companies, OPC cannot carry on non-banking financial investment activities, including investment in securities of any body corporate. This is another major hit for the foreign guys who come to India. Na? 3 years he'll be in America, he'll think he's American, he'll come. He'll be going on H1B visa and coming. But the way he'll talk will be as if he's some god. And then he will say, Mr. Srikanth, I want to form a holding company. Can it be an OPC? Sorry, no. OPC cannot be used for holding securities. No, I want to invest in many companies. Form a private company, boss. Using that, you invest. No problem. But not OPC. Okay. Means you cannot form an OPC as a holding company to hold shares. Cannot carry out non-banking financial investing activities. You got it? LLP you form. No problem. That's what I normally tell them. If you don't want private company, OPC not possible, go for LLP. LLP, you do anything you want. Most of my clients who have shares in foreign companies or Indian companies have formed LLPs. And these LLPs hold shares in various companies. They hold. LLP is the shareholder. Okay. And the LLP will be owned by my client and his family. Like that, I have set up things. If OPC cannot be used. Sometimes, when we give like this, these people will be getting angry and they will say, no, I saw in Google. Boss, you saw in Google, no, go to Google and ask them to incorporate. I can't incorporate for you because I am bound by the Companies Act 2013. Okay. I'm not bound by Google. Google Act, I'm not bound. I'm bound by the Companies Act 2013. See, there were certain conditions about paid up capital, annual turnover and all for conversion. Abhi, these conditions have been removed. So don't bother. Okay, they have been removed. Rule 6 and 7 have been amended. Okay, now what we're going to see is conversion of OPC into private company or public company. Procedure for conversion of OPC into a private or public company other than Section 8. First of all, you alter on MOA and AOA. First of all, remove that 1% and all. Minimum number of members should be increased to 2 or 7 and directors 2 or 3. Public company, minimum number of directors 3. Private company, minimum number of directors 2. Okay. Minimum number of members, private company 2, 7 for public. Increase all that. Minimum paid up capital, if any, you should be maintaining. Then make an application to the ROC, INC 6, altered MOA, copy of resolution, list of proposed members, along with consent, directors, list of creditors, latest audited balance sheet and P&L. Once everything is filed, the registrar will go through it. Okay, go. Then he will convert it from OPC to private company. Okay. Similarly, you want to come back. Only private company can become OPC. Are you able to understand? Public company cannot become OPC. Only private, because basically OPC is coming under private company guys. Public company cannot become OPC. Private company can. Okay, you pass a special resolution, obtain no objection from all the members and creditors, file the copy of the special resolution along with MGT 14, apply in E-form INC 6 with all the documents. Declaration by directors that all members and creditors are given. See, because you are converting a private company into an OPC. Are you able to understand? So, obviously, if there are 3 members, 2 members' shares are to be acquired by 1 member. And then only OPC it will be. Okay. And you convert into OPC, then acquire that shares, then you will be OPC, 1%. Okay. Once everything is satisfied, the ROC will issue the certificate of incorporation as a OPC. So remember, private company, OPC can be converted into private or public. But only private company can be converted into OPC. OPC cannot be converted into Section 8 company. Section 8 company cannot be converted into OPC. Even a private limited Section 8 company cannot be converted into OPC. Try to make a note of all this in simple terms in a book. Later on, that notebook will become a quick reference. So it's one day before exam. Though my own slides you can use, but remember, nearing the date of the exam, if you take my entire slides for this subject, it will go to huge number. Each slide will be minimum 50. And management and administration easily 170, 180 slides. So if you total up everything, easily 1,000 slides will be there. 800 to 1,000 slides will be there. You can't revise it. So that should be further reduced into notes in a notebook. And that should become my revision. Then it will be very. So in the exam, when you go, immediately check. You'll know which point. Oh, no. It cannot be done. Immediately you'll start writing the answer. So there are some exemptions for OPC, like it is not required to file cash flow statement. The annual return, we'll be seeing it in management administration, can be signed by the director and not company secretary. And they may prescribe an abridged annual return, which they have not done. Similarly, section 134, which is signing of audited financial statements, it is enough if one director signs, because there will be only one director. So one director can sign audited financial statements. Okay. Certain specific provisions related to general meetings, etc., EGM 100, 111 are not applicable to OPC. When you come to management and administration, either I myself or somebody will teach you. Okay. Also, in advanced syllabus, there is a relaxation on holding of board meetings of an OPC. OPC is required to hold only one meeting of the board in each half of a calendar year. So 6 months once, that is in each block. So from January to March, April, May, June, then July to December. Why I say January? Because calendar year. The minute they say calendar year, 1st January to 31st December. If they say surf year, it is always calendar year. If they only say year, it's calendar year. But if they say financial year, then not calendar year. So please note it. In the Companies Act, if anywhere you find surf year, YEAR, only year, then it is calendar year. But if you see financial year, then it is financial year. When it is only year, you cannot say financial year. It is only calendar year. Okay. Under section 137, OPCs are allowed to file financial statement within 6 months as against 30 days. Normally, other companies 30 days. For OPC, 6 months. Exemptions are given. I think we have covered up to my target. Today, I was targeting OPC. We have covered it. I'm very thankful to you for your cooperation. Some more questions are there. Deepika ji, INC4, INC3 is the consent. Just you should know which is what form. Then you won't have this doubt. INC4, it's a good question. And what is given in the institute material is correct. Okay. Now, whenever there is any change in the nominee, etc., first, if you are appointing a new nominee, that new nominee should give consent in INC3. Are you able to understand? In the case of replacement, or when nominee becomes member and appoints a nominee, in all these cases, that new nominee, proposed new nominee, should give his written consent in form number INC3. This will be filed by the member with the company. Then the company within 30 days will file the intimation of the name of the new nominee in form number INC4. So what is given in the material is correct. What I have given also correct. There is no confusion. Unless you want to get confused, don't get confused. INC4 alag hai, that is filed by the company to the ROC. INC3 is consent given by the nominee, which along with that, the intimation should be filed by the member to the company. Okay. So, let us see any more questions and then current state what happens, sir. Okay, studying material is one answer. Correct. Deepika, I hope you got. Benefit of OCI, I told see, when you come through from India, I have come many times, I'm an Indian citizen. So I get one straight route I go. The foreign citizens have to go through another route. When I go to foreign countries, that country citizens will go walk in straight. Whereas foreigners, there will be a separate queue. We have to go there a little longer, it will take. And they'll be more careful in scrutiny. Whereas Indian citizens or their local citizen will walk. Now, in India, this OCI will come into a sort of a middle category where he will not be treated as a foreigner, but he won't be treated as an Indian citizen also. For OCI, there will be one separate entrance. So he will waive that OCA card and he'll go. Okay. That's all. And he can stay in India for however long he wants. Okay. It's a kind of recognition given by the government for people who were once upon a time, when citizens, once upon a time born in this country. Now they are saying get out and they have gone away. Sir, only two conditions are given there. Okay. The other method is when I can cease to be a member by selling my share to somebody else. Now, in that case, the member, instead of me, it will be somebody else. That's all. Whereas, when the member dies or becomes incapacity, that there will be no member now. But whereas, one more method of me ceasing to be is to sell it to you. But then you will become member. So there will be one member always. But if a member dies or incapacity, there will be no member. At that time, the nominee will come. Okay. There are only two methods. To my knowledge, no other method of becoming. OPC definition is given in sorry, one second. See, this is okay. I do it like this. That's easier. (262) is the definitional section. 3(1)(c) is the section pertaining to OPC. Okay. But 262 is the definition of OPC. 262. That's all. Okay. Member is a person member in 2 OPC. Sorry, he cannot be. Sorry, that's all. It cannot be done. Don't even say he's a person. It cannot be done. If at all, then he has to sell his share. Okay. Sure. Sell his share. Okay. Thank you for confirming, Krishnaji. And how OPC's meeting is conducted. Nothing. OPC meeting, nothing. That one member will come, he will sign the resolution and go. That's all. No need to have meeting also. You can simply come sign the resolution. That's all. See, after all, later on when you come to meeting in administration, you will understand this. It's not very difficult. Simply on the appointed time and date, that one person will come, sign the resolution and go. That's all. It's over. Sign. That's it. Resolution passed. Only one member. Na? See, no need for all that. Yeah, that's all. Thank you, Mr. Krishna, for giving such kind words. Thanks for becoming interested. It's a very interesting subject. Thank you for that. So let's hope there are no more questions. With this, I will close the session. I thank you for your support. And next class, we will begin with Section 8, Formation of Companies and with Charitable Objects. Thank you very much. Thank you. Directors also will be there. Minimum 1 director, maximum 15 directors. Okay. Thank you. Thank you. Yes, even OPC accounts have to be audited by a chartered accountant. Later on, when you come to audit and auditors, accounts, etc., you will be taught. Don't worry. Thank you. Bye.